You guys can have a seat. Just give me 1 second.
Okay. Didn't want to bring you back too late. Thank you very much.
Okay, before we get going, do any of my judges see any conflicts? And do any of the advocates in their second chairs see any conflicts with judges? Oh, you're on. All right. All right, this is the estate of Peter Jones versus Dragon Studios. Are both parties present and ready to proceed?
Plaintiff's ready to go, Your Honor.
Defenses as well.
Awesome. All right, I'll hear appearances for the record.
Yes, Your Honor. Good afternoon, Your Honor. My name's Jackson Kunde. Today, I represent the plaintiff in today's case, the estate of Mr. Jones. Joining me at counsel table is Ms. Lauren Stoneman.
Good afternoon, Your Honor.
Good afternoon.
Would you like to hear appearances from the
Yes,
defense?
please.
Good afternoon, Your Honor. My name is Devika Narendra, and today I'm joined by my colleague, Ms. Johnny Wynn.
Good afternoon, Your Honor.
Together, we represent the defendant, Dragon Studios, and we're joined at counsel table by the representative, Ms. Cole Doyle.
Good afternoon, Your Honor.
Hi. All right, are we ready to open, or is there anything we have to discuss before we do that?
A few things to discuss, Your Honor. First, we've got a few exhibits in today's case. Actually, quite a few, Your Honor. Exhibits 1 through 25, both parties have agreed that those exhibits are pre-admitted.
Okay.
And we'd like to actually use Exhibit 2 in opening statements, if that's all right with Your Honor.
Do you have any objection?
No, Your Honor.
Then that's permitted by agreement.
Yes, Your Honor. And second, we'd like to invoke Rule 603 and 615. That's the constructive swearing in and sequestration of all witnesses, barring party representatives.
Okay, so all witnesses are going to be considered sworn with respect to sequestration. Do you have any objection to all witnesses being sequestered?
Yes, Your Honor. Ms. Cole Doyle will stay with us. Pursuant to Rule 615, she's going to be our party representative and will remain here during trial.
Is that okay?
Sounds great, Your Honor.
All right, we have an agreement on that then. What else?
Last, Your Honor, we'd like to ask for your permissions for moving about the courtroom, approaching the members of the jury, the witness, Your Honor.
Yeah, so are we going to have our witness here or there? I'm amenable to whatever the two of you are amenable to.
I believe we're going to have our witness sit there, if that's fine with plaintiff
Okay.
counsel.
Sounds great.
That works for me. So my rule is, to the extent that you're going to approach the jury or me or an opposing witness, please ask permission. Otherwise, do whatever you want. So you don't need permission to approach your own witness, and to the extent you want to make use of the room, please behave appropriately, but I'm going to give you pretty wide latitude. Okay?
Sounds great, Your Honor.
All right.
With that, we're ready to go.
Anything from you?
Just one thing, Your Honor. But we'd like to give the court notice that we're electing to pursue an affirmative defense in today's case, the affirmative defense assumption of risk. It's common in this jurisdiction to point the court towards the correct verdict form we will be using, and that'll be verdict form F in your bench.
Okay, so just so I make sure we're on the same page, you are conceding negligence or not?
We'll be conceding negligence, electing to just pursue the affirmative defense.
Okay, so conceding negligence, pursuing the affirmative defense of assumption of the risk, not pursuing the affirmative defense that you pled of comparative negligence, correct?
That's right, Your Honor.
All right, is that your understanding as well?
That's our understanding as well, that the defense is the only person with a burden in today's case because they've conceded that negligence charge.
Okay. Are we ready to open?
Yes, Your Honor, we're ready.
All right, you can
Let's
proceed
go.
when you're ready.
And, Your Honor, if I may approach the members of the jury to show them Exhibit 2.
This is one of those pre-admitted exhibits?
Yes, sir.
This is the one we talked about?
Yes, Your Honor.
Okay, yes.
Can you all see that all right? You're looking at an actor named Peter Jones. He's about to attempt a difficult stunt. Right now, there should be someone in his ear telling him when to pull this parachute, but by this point, something's wrong. That voice, it never comes. And by the time he pulls that chute, it's too late. That video cuts off because everyone in this room has agreed what happens next never needs to be seen again. Mr. Jones hits the ground at 120 miles per hour. He's dead instantly. This case, members of the jury, is about why. And you're going to hear it goes back to that person who was supposed to be talking to him in an earpiece, supposed to be telling him when to pull his parachute to be safe. You're going to hear that that person is the defendant's producer, Miss Doig. You're going to hear how Miss Doig waits and waits and waits until it's too late. Until no matter if Mr. Jones pulls that parachute or not, he's dead. The defendant wanted 15 seconds of film, and it cost a life. That's why we're here in court today. Now, today's a little bit unusual because even though we're bringing a suit against the defendant, that production studio, Dragon Studios, we actually don't have a burden. We don't have to prove a single thing to you. What happened in that video, they've agreed, is called negligence. So instead, it's actually this side of the courtroom that's going to be taking on a burden to prove their case, more likely than not, that what you saw in that video was something that Mr. Jones assumed the risk of. That it was his risk, his choice. Members of the jury, we're going to show you today that that's not true by showing you three things. That the defendant wanted a better movie. That she knew the risks. That someone's life was on the line. And she did it anyway. So let's start with that first piece, that this defendant wanted a better movie. Because what you're going to hear today is they shot that stunt the day before 6 times, just like they planned, just like they planned to be safe, just like their contract said. But you're going to hear that to this defendant, that stunt wasn't good enough. That she needed it to be longer. So you're going to hear that she was willing to put Mr. Jones, that actor's life, on the line. That she was told by experts, you have to tell him to pull that chute at 9 seconds. That's the last time he can pull that chute and still be safe. And you're going to hear what this defendant did at 9 seconds. Nothing. That not once during that video, and in the 15 seconds it takes for him to hit the ground, does she say anything. So members of the jury, in a few moments, when my opposing counsel comes before you and talks about the burden they took on, to remember that that's only their burden. The defendant wanted 15 seconds of film, and it cost a life. That's why at the end of today's trial, I'll come before you again, and I'll ask you to find Dragon Studios liable for that negligent act you saw. Thank you very much.
Thank you, counsel. Ms. Narendra, you can proceed when you're ready.
Yes, Your Honor. You're on. Opposing counsel. Members of the jury. He took the risk for his reputation. This is Peter Jones. June of last year, he has a decision to make. He's just finished having dinner with his film executives, and they've given him two choices. Perform a riskier stunt, or risk lying to the press. Mr. Jones is given two choices. Take the risky stunt, or risk his reputation. See, members of the jury, throughout trial today, you're going to hear a lot about choices made for Mr. Jones. And the plaintiff here is going to tell you a lot about choices that the company producing this movie made. But what you'll see is every step of the way Mr. Jones was involved. And every decision that led up to his accident was a decision Mr. Jones made. He took the risk for his reputation. See, members of the jury, the plaintiff just got up here and told you about how we've elected to take on a burden, and that's right. Because when he showed you a video of the tragic accident, of how Mr. Jones died, I'm not going to stand before you and tell you what happened wasn't a mistake. No one today is going to tell you that Dragon Studios didn't make mistakes. No one is going to tell you what happened wasn't tragic. But what I'm going to tell you is that Mr. Jones was part of those decisions, and as hard as it might be to believe, Mr. Jones was part of those mistakes. That's why we've elected to pursue an affirmative defense in today's case. That means we conceded that Dragon Studios was negligent. And when we did so, we embraced a burden to prove three things to you. First, that Mr. Jones understood the risk of what he was doing. Second, that he volunteered to do so anyway. And third, that it was that risk that killed him. We'll prove each of these three elements to you today. And we'll prove them to be more likely than not, so I want to walk through them one by one. Did Mr. Jones appreciate the risk of what he was doing? I mean, members of the jury, you got to see it for yourself. He was on a motorcycle, on the edge of a cliff, about to drive straight off. And as much as everyone involved tried to make that safe, you're going to hear that Mr. Jones always understood it was risky business. You're going to see Mr. Jones signed a contract understanding what happened there. It could hurt him. It could kill him. And so did he do this voluntarily? See, members of the jury, we're going to call Miss Doy to the stand today. She was the one working with Mr. Jones on behalf of the film company. She's going to tell you she had a conversation with Mr. Jones the night before the accident. She'll make it clear. No one threatened Mr. Jones to do this. No one told Mr. Jones his job was on the line, his life was on the line. But that Mr. Jones was the one who wanted to do this. In fact, you're going to hear the film company gave him two options. You'll hear they offered to edit the footage, make it look longer, make it so Mr. Jones didn't have to take that risk. But you'll hear the moment the press was mentioned, Mr. Jones puts his hands up and says, "No, I can do it. I can do 9 seconds." And so that's what they did. You don't have to believe that was the right decision. You don't have to believe it was safe. You just have to believe that Mr. Jones volunteered to do it. And so third, that he died because of that risk. Members of the jury, the plaintiff told you the reason Mr. Jones died is because he never got the signal to pull. But you're going to hear that's just not true. Miss Doyle will take the stand today, and she'll tell you at 9 seconds she said pull. Mr. Jones didn't do it. As tragic as that is, that's not something Miss Doyle could control. It's not something anyone could control, because when he chose to drive a motorcycle off a cliff, he assumed that risk. He took the risk for his reputation. At the end of today's trial, I'll ask you to find Dragon Studios not liable. Thank you.
All right. Ready to call your first witness?
Yes, we are, Your Honor. Permission to call Mr. Goglion to the stand?
All right. Good afternoon.
May I proceed?
Whenever you're ready.
Good afternoon, sir.
Good afternoon.
Can you introduce yourself to the members of the jury?
Hi, my name is Eli Gogolian.
What do you do for a living, sir?
I'm a talent agent. I help out movie actors find jobs in Hollywood, try to get them good gigs.
Can you tell us how you got into that line of work, sir?
Yeah. I actually started in law school, believe it or not. I went to UCLA Law, and over the summer I did an internship. It was entertainment law. I loved it. I ended up finding out that I liked entertainment more than I did law, so I quit and went to go be an agent.
Well, sir, can you tell us how you're involved in today's case?
Sure. I was there when my friend Peter died on set.
Sir, can you tell the members of the jury a little bit about how you know Peter, Mr. Jones?
Everyone knew Peter as this big Hollywood actor. For me, he was just my friend. I met him on a set maybe 10 years ago. He joined my agency group, and from there we just hit it off. So I've been working with him for a while now.
And sir, I want to ask you a couple questions about that stunt
Okay.
Mr. Jones was doing. Would you recognize a video of that stunt if I were to show it to you?
I would. I was there.
And Your Honor, we're going to ask the witness be able to come down in front of the members of the jury and walk them through this video of this stunt, if that's okay with Your Honor.
Any objection?
Not at this time, Your Honor, no.
All right. Sir, I'm going to ask you to come down here, and wherever works for you to make sure the members of the jury can see this. Sure. Does that look all right to you, members of the jury? So, sir, before we watch this video, can you tell the members of the jury what they're about to see?
Sure. So this was for, the new movie we were working on. It's kind of Tom Cruise action flick. What Peter was supposed to do was ride this bicycle off a cliff. And he was going to jump out, and we had a parachute system that was going to send him down to the ground.
Sir, how long after he jumps off that cliff is Mr. Jones supposed to pull his parachute, to your knowledge?
The plan was we were going to do it 4 seconds after he jumps off. He was going to get, a message in his ear. We had an earpiece, and that's when he was going to jump. That's how we would know.
So that message you mentioned in his ear, can you explain that a little bit more?
Sure. So there was a control room that we had set up, and we'd watch the video that you're seeing now on tape. We'd watch it, wait the 4 seconds, and then somebody, usually Cole, would give him a signal, tell him, all right, time to pull the parachute.
Sir, before we get into that video, on this day, who was it that gave him that signal?
Cole?
And so let's go ahead and play this video, and if you just tell the members sure exactly what's happening.
Sure. So you can see we built the ramp for him to drive up off of over there. He jumps off. And now he gets the signal to pull the parachute. And you can see it start to come out right there. And he lands safely.
Sir, what happened after this video?
He got to the ground and people were pretty excited about it. It was cool. And Cole came up to him. And she didn't really seem happy.
What do you mean, sir, that Cole didn't seem happy?
Well, she said they needed to do it again, that this time she wanted him to wait to pull the parachute, that the film she was getting, it wasn't long enough. It was too short to be compelling.
Too short to be compelling. Are those the defendant's exact words?
Yeah.
And sir, can you tell us what happened the next day?
Well, the next day, we do the stunt again. So it's in the morning, we're in the control room, and it's me and Cole standing in there. It's the same setup. She's supposed to give the signal.
Sir, would you be able to walk us through that second video of that stunt on that day?
Yeah, I can do it.
And now, sir, I'm going to play this video for you, and I just want you to tell me when to pause it. When the defendant tells Mr. Jones to pull his parachute. Okay?
I can do that.
Okay, he's going up the cliff here.
Yeah, and then he jumps. And that's when the clock starts.
So right there, it's been about 4 seconds.
Yep.
Sir, at that point, did the defendant tell Mr. Jones to pull his parachute?
No, I was in the control room, with Cole, and I was watching it happen. And at this time, I was getting a little worried about it, but I thought it was okay.
Okay, so I'm going to play the video a little bit longer. So that's about 9 seconds. At this point, had the defendant told Mr. Jones to pull that parachute?
No. At this point, I'd said to her, I said, hey, we gotta pull the parachute. It's been too long. She just went like this.
I'm going to play the rest of that video, and sir, whenever Miss Doy says to pull the parachute, you just let me know. So you never stop me.
She never did in the signal.
Your Honor, at this time I'd ask the witness to take a seat.
Okay.
Sir, after Miss Doy didn't give Mr. Jones this signal, can you tell us what happened next?
He doesn't get the signal, and eventually he just pulls it himself. It was too late. He was going fast. I saw him hit the ground.
Sir, after Mr. Jones hit the ground, did you hear the defendant, Miss Doig, say anything?
We took a helicopter down the mountain to see what was going on. And when we got there, I asked her, what were you doing? And she just said, I wanted to make the shot longer. And that was that.
And sir, I want to ask if what happened in that second stunt run was ever a part of the plan. Sir, did you ever hear Miss Doy say to Mr. Jones that they were going to wait 15 seconds?
No. The plan was always, it was supposed to be 9.
Sir, did you ever sign any contracts about what was supposed to happen in that jump?
We did. We all did.
Sir, would you recognize those contracts if I were to show them to you?
Yeah, I would.
Your Honor, approaching opposing counsel with Exhibit 33. Approaching the witness. Sir, are those the contracts?
Yeah, that's it.
Your Honor, this time you offer Exhibit 33 into evidence.
Any objection?
Without objection.
All right, submitted.
Sir, I got one last question for you. Anywhere in those contracts does it mention waiting 15 seconds before telling Mr. Jones to pull the parachute?
Nowhere in the contract does it say they're gonna wait 15 seconds to tell.
How long does it say, sir?
4.
Thank you very much. Nothing further. Your Honor.
All right, Cross?
Yes, Your Honor. Good afternoon, Mr. Gogian.
Good afternoon.
My name is Devika, Narendra, and I'm going to ask you some questions on behalf of Dragon Studios, okay?
Okay,
I want to start by saying I'm sorry for the loss of your friend.
thank you.
I'd like to start at the beginning of this whole stunt proposal. Now, this motorcycle stunt, you'd agree it was Peter Jones' idea, right?
Yeah,
Objection, Your Honor. The question calls for speculation.
Response?
Yes, Your Honor, if I may proffer.
Yes.
It was Peter Jones who proposed doing this stunt. My next question to him was the fact that Peter Jones proposed this stunt.
I'm going to sustain the objection. Obviously, I think, as you suggested, the question that you're going to ask next, I think, would solve the problem. But I'm going to sustain the objection as to that first question.
Yes, Your Honor. You'd agree with me it was Peter Jones who proposed this stunt, right?
that's right. He'd come up with the idea.
It wasn't you.
No, I'm it's good heights.
Wasn't Miss Doyle.
No.
It was Peter's idea to do this stunt.
Objection, Your Honor. Again, we re-raise our objection
Sustained.
to speculation.
Peter proposed to do this stunt.
Again, to ask and answer.
Overruled.
Yes, Your Honor.
He did.
He did. Now, Mr. Gogian, I want to talk a little bit more about what you were going to do to make this stunt safe. You had a plan, right?
We all did. Yep, we came up with a plan.
You and Miss Doig and Mr. Jones, you created a contract that you mentioned, right?
That's right.
You were shown that contract just a moment ago.
That's true.
Would you recognize it if you saw it again?
I would.
Approaching opposing counsel with Exhibit 33 and handing it to the witness.
Thank you.
Now, Mr. Gogian, this is the contract that you just saw. It was the one that you drew up, right?
This is the one we drew up. That's right.
Mr. Jones read this.
Yes.
Mr. Jones signed this.
I was there. Yeah.
I want to talk about what this contract says. This contract is an agreement about the stunt that Mr. Jones was going to do.
Yep, we made a lot of documents about the agreements. This is one of them.
This contract, it says that the stunt, it could injure Mr. Jones, right?
That's right. It does.
Says the stunt could involve Mr. Jones dying.
It says that. It does.
You see, Mr. Jones signed it at the bottom, right?
He did.
Now, on direct examination, you told us a little bit about something Miss Doig said. You said that she wanted the film to be longer, right?
That's true. She did say that.
You told us about a conversation between Miss Doig, yourself, and Mr. Jones the night before the accident.
Yes, she came up, she talked about how she believes the footage should be longer. We should do another take.
I want to talk about how Mr. Jones reacted to that. Initially, you thought he seemed hesitant.
That's what I thought.
But then Miss Doig brought up the press, right?
The press, sorry.
Miss Doig said, well, we could edit the video, right?
Right, well, she had talked about, she had said that there were basically two options, right? There was, we could edit the video, and make it look a little shorter, or, we could make the video longer, and it'd be safe.
Right, she gave him two options, edit the video or make it longer.
You got it right.
And it was Mr. Jones who decided to make the stunt longer, correct?
Yeah, well, they had brought the idea, yeah, Peter agreed.
It was because when Ms. Doig talked about editing the video, she asked Mr. Jones a question about the press. You'd agree?
I think so.
She asked Mr. Jones, if we edit the video, do you want me to lie to the press about that?
That's right. She had said, we could edit the video, but, I don't really want to lie to the press about it when we talk about the CGI part. It's supposed to be no CGI.
And when Ms. Doig asked Mr. Jones if he wanted her to lie to the press, Mr. Jones agreed to make the stunt long, right?
That's right. Peter said, no, don't lie.
Mr. Jones agreed to make the stunt last 9 seconds.
That's right. That was the agreement.
Now, on direct examination, you told us that Ms. Doig never signaled for Mr. Jones to pull the parachute.
She never did.
You told us she waited 15 seconds.
She never signaled, even after the 15 seconds.
Mr. Gogian, I want to talk about whether that's true. You'd agree with me, in that control room, there were only 2 people.
That's right. It was me and her.
It was just you and her.
That's right.
She had a walkie-talkie in her hand.
She did.
It was connected to Mr. Jones' earpiece.
That's right.
You're saying that she never gave him that signal.
She never did. I watched her not do it. I told her to give the signal.
Mr. Gogian, no one else was in the room.
No, it was just me and her.
You didn't record it?
No.
There were 12 other crew members involved.
That's right. Different stations across the area.
You didn't call any of them?
During it? No. He was in the air.
You didn't tell any of them that Miss Doig failed to give the signal?
I did. In front of everybody. I asked her, why didn't you give the signal?
Mr. Gogian, right now, it's only your word against Miss Doig's that she never gave that signal.
I guess.
I wanna
But she
talk-
did.
Mr. Gogian, I want to talk about why you might not be telling the truth.
Objection, Your Honor. Counsel's testifying.
Sustained.
Mr. Gogian, I want to talk about why you're telling us that Miss Doig never gave a signal.
Okay.
You've been working with Peter Jones for years.
I have been.
He was one of your main clients.
He was.
Made you millions of dollars.
From all the movies. That's right.
But more than a client, you'd consider Peter Jones a close friend, wouldn't you?
Yeah, he was.
Thank you for your testimony. We've got nothing further.
All right, are you erect?
No, Your Honor, we just asked that the witness be excused.
Okay. Do you have any further evidence to put on?
No, Your Honor, the plaintiff rests.
All right. Ms. Narendra, are you putting on a case?
Yes, Your Honor. We call Miss Cole Doig to the stand.
Okay.
Need this back? I'll retrieve that. Thank you, Miss Doig. May I proceed?
Yes.
Good afternoon. Can you introduce yourself to the members of the jury?
Hi, my name's Cole Doig.
What do you do for work?
Well, I'm the founder and owner of Dragon Studios. We're behind the All Lost franchise.
How'd you get into that?
As a kid, I dabbled in some community theater. I was doing some production of Charlie and the Chocolate Factory, and I got cast as the grandfather. Not the one that goes to the chocolate factory, the one that stays in the bed. So I thought it might be better if I stayed behind the camera and became a talent. My apologies, a producer.
Well, Ms. Doig, why are you here testifying today?
I'm here because I was working on the movie with Peter when he died. I was in the control room.
Can you tell us a bit about how you know Peter Jones?
Well, Peter and I worked on a bunch of different movies together. He was the star in all 7 of the All Lost movies.
Ms. Doig, you mentioned that there was a stunt that went wrong. Could you tell us what that stunt was?
Yeah, so the way the stunt was supposed to happen, Peter was supposed to get on the motorcycle, drive off the ramp, release the bike and parachute to the ground.
How did you prepare him to pull off a stunt like that?
Well, we made agreements. We made a stunt plan with the stunt coordinator. We made sure to sign a contract, make sure he was informed of all of the risks.
Did Peter get to read both of those things?
He signed both of them.
Would you recognize that stunt plan and contract if you saw it today?
Yeah, I think I would.
Approaching opposing counsel with exhibits 34 and 33. And approaching the witness. Mr. Wood, can you identify the two documents I just handed you?
So this here on the left, this is the contract that we signed. It was signed by Peter, Eli, the talent agent, and me. On the right, this is the stunt plan, so this is where we decided what the stunt would look like.
And that stunt plan, does that look to have been changed since you last saw it?
No, it looks the same.
Defense offers exhibit 33.
Any objection?
No, Your Honor.
All right, it's admitted.
Now, Mr. Wood, I'd like to walk through these one by one. The contract. Can you tell us why you drew up this contract?
Look, you always have to write contracts before you do any sort of dangerous stunts like we were doing in this movie. So we wanted to make sure that Peter knew about the risks that might be involved in that stunt and that he was okay with that.
What sort of risks does the contract mention?
Well, you can see right here in the bottom paragraph it says, performer accepts the normal risks of filming a movie, including risk of physical injury on set. And later it mentions the risk of death.
Did Mr. Jones sign this?
Yeah, this is his name at the bottom.
I want to turn to that stunt plan. Mr. Wood, who prepared it?
This was prepared by the stunt coordinator, a woman named Sky Stebbins.
How long does the stunt plan recommend Mr. Jones perform the stunt for?
Well, it says on the stunt plan that the signal should be given to him at 4 seconds, and he would release the parachute and fly down safely.
Mr. Wood, you've been sitting with us throughout trial today. Did you hear when it was said that you didn't give a signal until 9 seconds, that became the plan?
Yes, I read that.
Could you explain to the members of the jury why the 4 seconds changed to 9?
Well, we didn't have enough footage for the movie, so I made sure that Peter was okay with extending the stunt so we could get a little bit more footage.
Did Peter agree to perform the stunt for 9 seconds?
He did.
This might sound like an unconventional question, but did you threaten Peter to agree to that?
No, of course not. I explained to him that that we could extend the stunt, get a little bit more footage, and he said he was okay with that.
Did you give Peter other options as to how to make the scene longer?
I said that we could edit the footage, maybe try and make a scene look longer, but he agreed. He wanted to extend the amount of time it took to do the stunt.
And Mr. Wing, I'd like to turn to the day of the accident itself. Can you tell us how it started?
It started like it always did. Got on the motorcycle, rode down the ramp, jumped off the motorcycle, and started to free fall.
Were you watching his altitude as that was happening?
Yes, of course. I was in charge of giving the signal.
Were you keeping track as the time went by?
Yes, of course.
Ms. Doyle, at 9 seconds, did you give Mr. Jones a signal?
Absolutely, I gave him the signal, just like I was supposed to.
If at 9 seconds you told Mr. Jones to pull the parachute, what did he do?
9 seconds went by. I gave him the signal. I radioed. I said, deploy, deploy. And nothing. He just kept falling. So after a couple seconds, I radioed again. I said it again, deploy, release your parachute. Nothing.
What happened?
After about maybe 16 seconds, he finally pulled the parachute, but he was going too fast. He was too close to the ground. At that point, it was too late.
Mr. Wick, I've just got a few more questions for you. I want to make one thing very clear. Did you wait 15 seconds before giving him a signal to pull?
No, of course not.
Did you follow the plan that you and Mr. Jones had agreed to?
Yes. Just like I told him, I gave him the signal at 9 seconds.
Thank you, Mr. Doyle. Nothing further, Your Honor.
All right, Cross?
Yes, Your Honor. Good afternoon, ma'am.
Good afternoon.
Ma'am, I want to start by talking about how exactly we've ended up in this courtroom, okay?
Okay.
Because you'd agree the day you planned to do the stunt we've been talking about, Mr. Jones was safe.
Yes, that's true.
He did that stunt, the stunt you planned, 6 times.
Yeah, the day before we had filmed 6 different takes.
6 times he went off that cliff, he threw out his parachute, and he was okay.
Yes, that's true.
Until you looked at that footage.
I'm not sure what you mean.
You looked at those 6 different takes, and you told us that wasn't good enough.
Yeah, I thought that we could use more footage, maybe we could edit something together, or get a longer shot.
And this is the cavern that Mr. Jones was jumping into.
Yes,
You wanted him to wait longer, get closer to this ground for your movie.
I asked him if that was something that he would be okay with, and he agreed to it.
I want to talk about that for a moment, because ma'am, you have those contracts in front of you, right?
Yes,
You got the contract and you've got the safety plan, right?
yes,
You told us a few moments ago that Mr. Jones agreed to this stunt on the 21st, that second stunt.
yes, that's true.
I want to talk about what this contract actually says. Because this contract says the performer accepts the risks, including risk of death, of the stunt described in the attached stunt plan, right?
Yeah, that's referring to the original stunt plan, yes.
You'd agree, the stunt plan that this describes says he'll wait 4 seconds before pulling his chute.
Yes, that's true, that was the original plan.
Doesn't say 9 seconds.
No, that's something Peter and I talked about later.
It certainly doesn't say 15 seconds.
No.
Then I want to talk about what happened. Because ma'am, you'd agree that this is a poster from the movie you were promoting, right?
Yes,
So ma'am, after you saw those 6 different takes, you decided that 4 seconds, well, it's not good enough for this poster, is it?
I'm not sure if we'd made the poster yet.
And you're telling us that after Mr. Jones died, you made this poster?
No, I'm sure we made it beforehand.
Okay. So 4 seconds, that wasn't good enough to plaster this all around Hollywood, was it?
I mean, I hadn't seen the poster, it had nothing to do with the poster.
And I want to talk about what happened. Because Mr. Jones, on the next day, he went off that cliff, right?
Yes,
4 seconds passed, right?
yes.
You didn't say anything.
No, I was waiting for 9 seconds, like we agreed on.
Ma'am, you waited 15 seconds before you did anything to tell Mr. Jones to pull his parachute. Yes or no?
No, that's not true.
Ma'am, if what you just told the members of the jury was a lie, that wouldn't be the first time you've lied in this case, would it?
I'm not sure what you're talking about.
Ma'am, you were deposed before this trial.
Yes, I was.
You agreed you were asked what happened on the day Peter drove to his death, right?
Yes.
And you said, I don't remember.
I think that's referring to what was said at the scene later.
Right, ma'am, later at the scene, you were asked what happened.
Yes, that's true.
You said, I don't remember.
Yeah, I didn't remember. It took me a couple of seconds.
That was a lie, ma'am. You did remember.
No, that's not true. I didn't remember until I took a couple seconds to collect myself, thought about it a little bit more, and I told the attorneys anything I could remember.
Well, let's talk about if that's true. Your Honor, approaching the witness with the deposition.
Okay.
That's that deposition we were just talking about.
Oh, yes.
You were asked, what did you say right there, in front of the crew, on the ground?
Yes, that's true.
You say, I don't remember.
Yes.
Then we say, I can depose the crew members, what did you say right there? And suddenly you do
Objection to
remember.
hearsay.
Response?
Your Honor, we're using this for the purposes of impeachment. The witness testified that she was emotional, she didn't remember at the time. The words in this deposition directly contradict that.
Is there a specific statement that you're objecting to?
Yes, Your Honor. The statement from the deposing attorneys that they could reach out to other people that were there, Your Honor, there's been no direct contradiction. What Ms. Doig said was that first she didn't remember, a few seconds passed, and then she told the attorneys what happened. That's what happens in this deposition.
Your Honor,
Yes.
if we can just settle this real quick. These are statements by a party opponent.
Well, I agree with you that the statements by the witness would be statements by your opposing party. I think counsel's objection is to,
It's to the attorney's statements, Your Honor, not Ms. Doig.
it's specifically to the first sentence on 252, is that right?
Yes, Your Honor. That's right.
The sentence, just for the record, I can depose the crew members from the attorney.
That's right, Your Honor.
What's your response to that?
Goes to the effect on the listener in changing that story from I don't remember to telling what actually happened on the ground that day.
One last response, and then I'm gonna rule.
Yes, Your Honor. This does not have a direct effect on the listener. What Ms. Doig said was that it was just the passage of time, taking a few seconds to collect herself, that then she remembered. There's no specific effect that this sentence had on Ms. Doig.
Okay, so I'm gonna let the jury decide that. I'm gonna allow this line of questioning to continue, and the jury can give the line of questioning whatever way they see fit. So
Yes, Your Honor.
overrule with that, with the limiting instruction that is to be only considered for the effect it had on the witness, not for its truth.
Yes, Your Honor.
All right, proceed.
Ma'am, a few moments ago, you told us, you say you don't remember because you needed a few minutes, right?
Just a few moments to collect myself. The attorney was pushing me on it, thought a little bit more about it, and I told them what I could remember. It wasn't much.
Then we say, I can depose the crew members, yes or no?
Yes.
And the next thing you say is exactly what happened on the ground that day.
I told the attorney anything I could remember.
Ma'am, you're asked, how could you do this?
Yes, that's true.
This is not in front of the jury, right?
No.
This is on the ground after a man has lost his life.
Yes, that's true.
You don't say, I didn't do this.
No, I was in shock.
You didn't say, this was my fault. It's not my fault.
No.
You say, I wanted a longer scene.
Yes.
You say, I thought we had enough time.
Yes.
Nothing further.
Redirect.
Permission to approach and retrieve.
Well, hang on, do you want to use those documents or no?
Yes, Your Honor.
All right, let's leave them up there then.
Ms. Doig, on cross-examination, you were just asked about saying that you wanted a longer scene. Did you mean 15 seconds long?
No, I didn't. I just wanted a couple more seconds of footage. That's what Peter and I talked about. That's what he agreed to.
So to be very clear, how much longer were you planning on making the scene?
5 more seconds. From 4 seconds to 9 seconds.
Did Mr. Jones agree to that?
Yes, he did.
Thank you, Ms. Doig. Nothing further at this time, and barring recross, we'd ask you to be excused.
Can you recross?
No, Your Honor.
All right, she can retake her seat at council table.
Ms. Doig, I'll approach and retrieve those. I believe this one's yours.
Thank you.
Yeah.
Ms. Narendra, do you have any other evidence, excuse me?
No, Your Honor, at this time we rest our case in chief and we're ready for closing arguments.
All right, why don't we take 30 seconds for you guys to collect yourselves and prepare for closing arguments, and then we'll get going. Mr. Kunde, are you ready to proceed?
I am.
Closing arguments. Whenever you're ready.
Members of the jury, today the defense told you Mr. Jones was given two options. What they didn't tell you was the third one that they made for him. Because you see, when Mr. Jones jumps off that cliff on the 21st, he's waiting for a signal. He's waiting for this defendant to tell him when to pull the parachute. He's waiting for this defendant to keep him safe. But it never comes. This defendant wanted 15 seconds of film, and it cost a life. Members of the jury, today the defense has the burden. They have the only burden in today's case to prove their case is more likely than not that Mr. Jones assumed the risk when he agreed to do that stunt. But the problem, members of the jury, is you can't assume a risk you didn't know about. What we heard all day is that he knew about 4 seconds. He knew about 9 seconds, but it takes 15 seconds for this defendant to do a single thing. 15 seconds that cost Mr. Jones his life. And so today we told you in this trial we were going to show you 3 things. Let's start with that first one, that this defendant wanted a better movie, because what you heard today is what they had planned to do. What they had in these contracts was one shoot. The day before he died, Mr. Jones took a risk. He got up on that ramp and he jumped off 6 different times. Exactly what he agreed to in this plan. Exactly the risk he was willing to take. And you heard that for this defendant, that wasn't good enough, that she needed a longer scene. So you heard what she did. She told you today that she reached out to get it longer to 9 seconds. But what we heard today was something completely different, that it wasn't just 9 seconds, it was 15 seconds. A witness took that stand today who was in that control room, the only person other than the defendant that was there. And he told you how he was begging her, tell him to pull up, tell him to pull the parachute. But she waits. Her words, I thought we had enough time. She didn't. So you heard what happened. That Mr. Jones, waiting for that signal that this defendant was going to give him, waits. This defendant Mr. Jones puts his trust in this defendant, that this defendant will keep him safe, and he waits. Until it's too late, he decides he's just got to throw out his parachute. She wanted 15 seconds of film, and it cost Mr. Jones his life. And so today, you're going to hear that this case, it comes down to what that defendant did. And we heard 2 accounts. And members of the jury, just because we heard 2 accounts doesn't mean it's 50-50. You heard one witness on the stand today who was a friend of Mr. Jones. But who doesn't have a stake in this. There's no money that that witness gets for his testimony today. And he told you that at 15 seconds, only then did she do something. You heard the second account from the defendant who's on trial today. She swears that at 9 seconds, she's telling him to pull out that parachute. But what we heard today is that if she's lying, that's not the first time. That weeks, months ago, when we deposed her and asked what happened on June 21st, she said, I don't remember. Till we said, we can call witnesses who were there. And she said, okay, I do remember. What's different between that and what she's saying happened in the control room is that we don't have any other witnesses. We've got the one that took the stand today, and she thinks she can get away with it. But that's a problem for her, and that's a problem for the defense, because they have the burden. Opposing counsel came up here, and on the cross-examination of Mr. Goulian, she said, you don't have anyone else who was in that room with you. You don't have any security footage of what happened in that room. You don't have another person who can tell us that she didn't, at 9 seconds, call it in, tell him to pull the parachute. Has she forgotten that when we started this trial, when she walked in those courtroom doors, she took on the burden to prove that it was Mr. Jones who assumed that risk? So members of the jury, we're not left with much. We had an unusual position today to say we don't have a burden, we don't have to prove a single thing to you. That rests entirely on them. What we heard wasn't Mr. Jones agreeing to some risk. Because you can't agree to a risk you never know about. Find this defendant liable for negligence. Thank you very much.
Thank you, counsel. Closing argument.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury. What the plaintiff has been telling you throughout trial today is the defendant wanted 15 seconds, and it cost someone his life. That's not true. See, members of the jury, did Ms. Doig want 15 seconds of film? No. Ask yourself why she would. 9 seconds was enough, and 9 seconds was always the plan. That's why we brought an affirmative defense to you. Because every step of the way, Mr. Jones decided what he wanted to do, and the plaintiff can say over and over again that Ms. Doig wanted a longer movie. But you heard Mr. Jones did too. He was the actor in this film. You heard he cared about his reputation. He didn't want the press to think he wasn't willing to do this stunt. He had skin in the game. It wasn't just Miss Doig that wanted a longer scene. It was Mr. Jones too. And so two together came to an agreement. It was Mr. Jones' choice. So I want to take this in two parts. First, we can talk about whether Mr. Jones assumed the risk of the 9 seconds. But that's not quite what the plaintiff is arguing. They're arguing the 9 seconds never even happened, that Ms. Doig waited a whole 15. So first, let's establish, did Mr. Jones assume the risk of 9 seconds? I mean, at no point did the plaintiff argue with that. Everyone here agrees. The night before the accident, there was a conversation between Ms. Doig, Mr. Jones, and his talent agent. They gave Mr. Jones two options. We can edit the video, or you can do the stunt for 9 seconds. Mr. Jones chose 9 seconds. But the plaintiff here told you there was a secret third option that they surprised him with. 15 seconds. I want to talk about whether it makes sense for Ms. Doig to have waited 15 seconds. Because the plaintiff has made it very clear. Everyone involved understood this was dangerous, and the longer the time went by, the greater the risk was for Mr. Jones. They made it clear Ms. Doig understood 9 seconds was the latest she could possibly give the signal. They made it clear Ms. Doig understood waiting longer than 9 seconds would kill Mr. Jones. So members of the jury, what is the plaintiff asking you to believe? That in that control room, Ms. Doig randomly decides, you know what? I know waiting 15 seconds is gonna kill my best movie star, but hey, might as well take the risk. Maybe somehow it won't. Are they asking you to believe that in the control room with another person there, knowing waiting 15 seconds would kill him, she just decided to do it anyway? Or what, did she cross her fingers and say, well, I hope no one notices that I just waited 15 seconds. I hope the person standing right next to me doesn't tell anyone. I hope this doesn't fall back on me. Members of the jury, does that make sense? If she understood waiting 15 seconds would kill Mr. Jones, why would she do it? I mean, there's no reason to believe she wanted Mr. Jones dead. It's the exact opposite. The plaintiff has talked for so long about how much Miss Doig cared about this film, how she wanted this movie to be great. Members of the jury, the person who made the movie great was Mr. Jones. Miss Doig had every reason to keep him safe. And that's not to say mistakes weren't made. Because we're agreeing waiting that 9 seconds was a mistake. We're agreeing it deviated from the original safety plan. We're agreeing waiting 9 seconds was negligent. But that wasn't on Miss Doig alone. Because she gave Mr. Jones 2 choices. Edit the film or wait 9 seconds. Mr. Jones chose 9 seconds. And so at the beginning of today's trial, I told you we proved 3 things. We proved all 3 to be more likely than not. First, Mr. Jones volunteered to do this. No one forced him to get on that motorcycle. He proposed doing the stunt. No one told him if he didn't, his job would be on the line. Second, he appreciated the risks. You heard a contract was drawn up. It said 4 seconds could kill him. So surely he'd understand that 9 seconds could kill him. And third, that it was that risk that killed Mr. Jones. The plaintiff can tell you it was because Miss Doig never pulled the signal. But there's simply no reason to believe that. Why would Miss Doig kill her greatest asset? Why would she do it in front of someone? The story doesn't add up. Mr. Jones had a choice to make, and he took the risk for his reputation. I ask you to find Dragon Studios not lying. Thank you.
Rebuttal?
Yes, Your Honor. I'll answer a question my opposing counsel just asked. She asked, why would she do it if she knew it would cost a life? The answer is she didn't. Her words, the words she didn't want to admit to on the stand today when she first saw Mr. Jones's body. I thought we had enough time. All day they've been saying that he took a risk for his reputation, and members of the jury, we agree. That sounds a whole lot like someone in this case, but it's not Mr. Jones. this defendant, who wanted a better movie, wanted 15 seconds of film, and it cost Mr. Jones his life. Find him liable. Thank you very much.
All right, I'm gonna ask our judges to fill out their ballots, and then once I confirm here that I've got all your ballots, we'll